Hello everybody, Simon Dixon here. Today I would like to give a quick message for your Honourable Judge Glenn. The reason for this is I was listening to the hearing yesterday and we did a space afterwards. And there was a lot of talk around what was covered in the court hearing. And I just wanted to make sure that this is going in the right direction. Now, I know this is very unconventional and somebody will probably file motions and do this through the correct process. But I had a sense that there is information missing that is really needed in order to progress. So I wanted to just come on YouTube. I'm sure someone will follow up with a motion and make this happen. But I just wanted to make sure that there is some content out there that helps people understand the grand scheme of what is happening in the Celsius case right now. And the reason for that is because we need to progress at the right pace. We can see that from the court hearing that it was really heating up. There was talks around determining whether it's a Ponzi scheme. There were regulators there. There was a push for the bid. And then there was big debates around, minutiae little parts of the Celsius ecosystem. And I really wanted one place where we could just understand that if we don't solve these issues as a grand overview of how Celsius was designed and how Celsius worked, then we may be into weeks and weeks and weeks of delay where we get one motion, one hearing resolved, and then that leads to an objection, and then we go week after week after week. I've seen this time and time again. So with that in mind, the first part of this is to ensure that we have a comprehensive understanding of the different issues with the goal of ensuring that we move this conversation forward, because there was a person on the hearing, sorry if I can't remember your name, it was someone from the Celsius Loans group, an active member that has a loan on Celsius, that said we need to resolve all of these in one go and have a holistic understanding. Well, I think that person is right, and they came on the space after. So I just wanted to create this video, and then the second half of this video, I'm just going to be speaking to creditors. So you can just have the first part of this message, and I created some slides just to progress things as well. So I'm just going to move over to the screen share. And hopefully you can all see my full screen right now. Just to give context on who I am, my name is Simon Dixon. I'm the 21st largest creditor on Celsius. I've been around the Bitcoin space from the very beginning. I spoke at the very first Bitcoin conference, and I wrote the first published book in the world to include Bitcoin. And I've invested in over 100 different companies in the space through the platform banktothefuture.com, who is also intending to push forward in the bidding process a creditor-led bid solution. So just a little bit of background before I jump into the bulk of the content. We were, at Bank to the Future, we invested, and I was an investor in the Kraken seed round. That is now a pre-IPO $20 billion valuation that's looking to IPO. But they were involved in the solution for the Mt. Gox case. And because this went in the wrong direction, 8 years later, that is still trying to be resolved. But everyone needed to count in Kraken in order to try and reach a resolution. And we were around that as a shareholder in Kraken. Also in 2016, we were around the Bitfinex scenario where they had 119,000 Bitcoin whole. We were involved in the solution to try and progress that, where everybody settled by using equity and debt and various other instruments that we used on the Bank to the Future platform. Finally, in 2019, we supported Tether in filling an $850 million hole, almost a $1 billion hole in the end, but there was $850 million missing. That also led to a successful recovery. So the first one, Mt. Gox, we weren't involved in, was just done by a Kraken, and that's still going. The other two we were, and it got a speedy recovery and resolved the issue. At Bank to the Future, we've also been actively a shareholder or portfolio companies in some of the largest and most valuable brands in crypto from their very first raise. And you'll notice in the top left that Celsius is there. That's because 1,000 of our investors invested in the Celsius funding round in the Series A. And so a lot of at Bank to the Future, we were doing a partnership in order to build a security law compliant version of it. So that's the background. Now, that is why we understand and appreciate so much as Celsius, because we have been engaging with the community. I'm not a lawyer, I'm not an investment advisor, and I'm not a tax advisor. So please do not take any of this as legal investment or tax advice. But I'm somebody that is deeply and intimately understanding the ecosystem here. And for the last 4 months, have been involved in space and content after content and all the hearings in order to really get a good understanding of some of the challenges. And so why is Celsius unique? Well, Celsius is unique because essentially, according to the last coin report, there is a $2.7 billion hole or coin shortage to 600,000 creditors. So obviously, there are a lot of people that come from very diverse backgrounds, and it requires a very unique solution in order to solve some of these challenges. Now, the biggest complaint that I have at this stage is that if we are solving these problems one by one without taking a holistic overview, this is going to go on for too long. The examiner is going to release their report, and there are several things that I think are going to work to the worst of everybody. And the worst result is that these 600,000 creditors all get forced into a compulsory liquidation, even at its extreme, claims of being a Ponzi scheme, which is being discussed on the last hearing. But there are actually real assets within this company that can lead to a significantly better result by the creditors that believe in the future of our sector. So that's the unique problem. So there's 3 things and 3 solutions I'd like to share. The first one I think is relevant to the court hearings. The second is just for creditors, so you can switch off at that point if you're not a creditor. The problem, as I see it right now from the last court hearing, is that we have been through a few of these, and it is very fragmented. We keep taking one issue at a time when a holistic approach is going to get to a much better result. So I just want to make sure so that we don't end up with one hearing that then gets to an objection, that then leads to another, and we just end up in this process going round in circle again and again and again. There was also mentions of a determination about whether this is a Ponzi. The examiner very kindly came out and said, well, we'd just like to give you the facts and we'd like to break it down into pieces so that there's a phase 1 examination, a phase 2 examination. And quite rightly, it was focused firstly on property rights, which is the big issue that allows creditors to get through this process and where we need to get to. And what I want to do is try and prevent as many creditor battles, because if we can prevent those battles, I think we can have a significantly better result all round for all parties. I think the examiner can do what they need to do. I think the judge can reach the determinations that the judge wants to reach. I think creditors can get what they need to get. And I think regulators and those that want to serve justice can get it all at the appropriate time if we take the right approach of trying to get the best result for all parties. So in order to do that, the message that I wanted to give to Judge Glenn is about how to achieve a speedy property settlement. And by property, I don't mean real estate. In the UK, we call property real estate property. I mean property in terms of who owns what within Celsius. And if we don't take the approach of understanding the perspective, I wanted to give, from my understanding, a voice to the people that sit in these different categories. And I've broken it down. There could be more, into 8 different categories. And I believe that we need to look at all of them in order to get there. And then the second part of this is where we can talk about a compliant bid for creditors. This is creditor messages and the creditor, what I call creditor rebalancing through some of the work, that even if this goes on for too long, that there is solutions that we can work on as creditors. Okay, so let me jump into the speedy property settlement. It is my belief that maybe, I'm focused on the bidding process, but somebody should be filing a motion to ensure that there is a holistic approach so that we don't have fragmented people that are all filing motions from individual parts without understanding the whole. And so the whole, and I don't mean the whole as in the $2.7 billion whole, I mean the whole of how Celsius works. So let me just break it down as simply as I can. I'm sorry if you fully understand and appreciate these, but I just want to know that if you just rule on one thing like stables or custody, it's going to lead to other coming along objections, and this going on for weeks and weeks and weeks and not getting where we need to go in order to get to a speedy recovery for this. So every single person that signed up to Celsius signed up for either one of two reasons in the beginning. And there may be some exceptions, but pretty much everybody of those 600,000, they either signed up, if they actually deposited funds, they would have signed up to an earn account in order to invest in what is clearly a security. And because it wasn't sold to them as a security, they're all going to be complaining that they were misrepresented. As I felt, as everybody that's in the Earn program felt, that they were misrepresented. And so therefore, everyone in Earn is going to come back and say, well, you felt that you were misrepresented and therefore you got your coins. Everybody in Earn is going to come back and say the same thing. So Earn is really where people were promised yield and it was misrepresented to them, the safety of the product, the type of the product, and it wasn't suitably licensed in order to be offered, because it is a security and regulators are determining that, are going after everybody offering these Earn products. So that is the first one. The second is somebody that wanted to put some funds on Celsius and put it in collateral so that they could take out a loan. And most people did this because they believed in the future of their crypto. They didn't want to sell it, and therefore they didn't want to create a taxable event. And so they borrowed against their crypto rather than selling it because they wanted to hold it for the long time. Now, most of those people feel completely overexposed because they didn't really want to take massive risk with their money. They wanted to take out a loan. And therefore, in order to be over-collateralized and responsible, they probably ended up with a bunch more of their crypto or Bitcoin on the platform, and therefore they feel overexposed. They also have another side to their argument, which is that they would like to continue that loan relationship with somebody, but nobody wants to continue that loan relationship if they can't get the collateral with it, because that would make it either an under-collateralized loan or extreme risk of being taken out. And so the only two reasons why people had money pretty much on this platform is because they wanted some yield, so it was misrepresented as a security, or they ended up in their collateral being put in the Earn product, but so that they could take a loan, and they may not have fully understood what was happening there in order to allow for that loan to happen. Okay, so those are the two reasons why people would have money on Celsius. If you just determine and take those on their own, the challenge here is that if collateral is given to, for example, a bidder, then that would be diluted from what Earn would actually receive. And so the reason we need to take a holistic approach here is so that we don't end up in these big battles, one being resolved and then others coming back. The third is the stable coins. So in the last hearing, there was a lot of talk about stable coins. Stable coins are just simply some collateral or something you would have had in Earn. So there's nothing unique about stable coin. It's another crypto asset that people would have put in order to receive yield, or they would have put it up as collateral. And maybe there isn't even a use case there for having it as collateral. So most of the Bitcoin and ETH was for that. But stable coins are essentially a crypto asset, and it completely outside of the platform. The way that stable coins work, and I don't want it to be patronizing if people know this, they're either algorithmic, which means that there's nothing backing them, or the issuer of those stable coin has some dollars or cash and cash equivalents. My understanding is that there's no lien agreement signed there, but there is arguments for different, arguments being put forward that will need to be determined, so you can determine whether those that have stable coins, they believe they were misrepresented as well, just as everyone in the Earn program. and everyone that would have had collateral as well. But they feel that they were misrepresented, but they are trying to be secured creditors, and they're putting forward their argument of why they are secured, and so they should take preference, and therefore it would dilute others. Now, if you rule just upon stable coins, you're probably missing an understanding of all the other pieces and what will come next. Because obviously you know that there is custody, and custody are putting forward their arguments because when the EARN program was not available to certain US investors, US investors were forced into the custody program. And in some people, not everyone had this option. It wasn't available to international clients, as far as I know. But those US customers were put into custody because they didn't, and there was that 89 number thing before it filed for bankruptcy. So therefore, it gets into the preference issue, as you know, because there was reports that came out where the CEO of the company explained. The chief investment officer and compliance officer explained exactly how these custody accounts work and how they came to be. Now, maybe in times of fear, there's arguments that people move their money from EARN to custody rather than withdrawing it because there was fear around the market and people were withdrawing and they wanted it to be safe. But those are the arguments, and obviously they feel that the challenge is that those funds at some points were not, there was enough coins in custody, but at the point when people were withdrawing, they were commingled with EARN and there wasn't enough funds. So you're going to get all of those that's going to be presented. But if you treat it in isolation, you're probably missing all the other things that will come next. And so obviously that's custody. Now withhold, my understanding, and again, there's lots of documents out there, is that there were, when the service needed to move over to custody, there were certain states that they could not offer that service to. They wanted people to withdraw, and so they ended up in a withhold account. Now also, it looks like, as from the explanation, that those were, and I'm not giving any advice or any legal representation, I'm just saying the arguments from the perspective that are coming, they feel like, those funds were also commingled. And so other people will start having objections to that, and these need to be resolved. The sixth type is suspended. So you started to hear in the last hearing from somebody that had an argument where they're saying, well, my account was suspended. I wanted to withdraw, but I couldn't. And then Kirkland and Ellis will come and say, well, they had a breach of terms and service. Therefore, that is in line with the terms and conditions. But if you allocated those funds to suspended accounts, which they are right now, or if their argument is that they should get a full withdrawal because they should have been able to withdraw, then that dilutes the EARN. It goes into the property argument. And then remember things like stable coins, they could either have been in an EARN account or they could have been in a custody account. And so treating these things in isolation is not going to do the job. We need a holistic understanding from the UCC, which I'm sure they have, and Kirkland and Ellis, which I'm sure they have, and everybody that is fighting in the ad hoc groups to represent their arguments, and these to be resolved so that we can get a speedy determination on this. I have to say, I personally sit in the EARN account, but I really don't mind what the result is. I'm not fighting for any angle. I just want to know where we stand so that then we can work on solutions and get through this in a speedy process without having weeks and weeks and weeks of delays and motions. There is also liquidated loans. So after the pause happened, people had their loans and they didn't know whether to repay those loans or the price crashed, and therefore they were liquidated, they're collateralized, and they feel very hard done by because they wanted to put more, if service was done as usual, they wanted to put more funds into Celsius, but they were liquidated after the pause, between the pause or after the bankruptcy, that was still continuing, and people didn't want to put money into a bankrupt estate knowing that it could be haircutted. So they feel like they're, depending on the time of it, those funds those liquidated loans should be reversed. Now, if you reverse them, that's going to change the amount that can be allocated to either EARN, custody, collateral, stable coins, and all these things. So it's very important to treat this rather than individually really making these determinations. And then finally, there are people that feel like they had sell token and they bought it over the counter from the company or from the founders or from somebody, and they were sold those sell tokens. They entered into an agreement to buy them from Celsius. And then there was claims of market manipulation of the price. And then obviously the price crashed once some of these claims were coming through. And therefore those loans were all liquidated. They ended up with a big tax liability, just like the other liquidated loans. But they also feel that there was market manipulation involved in them ending where they are. There's all these different arguments that people are going to be put forward. I propose that we need to ensure that all of these are looked at the same time and not in isolation, so that property rights can be assigned, the correct legal arguments can be represented, and a determination can be put forward in a speedy fashion. And whatever it is, whatever it may be, if you are in one of these groups and you want to put together legal representation, file motions, then please get together in your groups and put those forward. But rather than just doing this as just stables, just custody, I don't think we're going to get the result that we need. And this is going to go on for months and months and months. That's going to be pushing, different examination phases that could lead to the worst result for everybody that we don't want. So I just wanted to put that message out there for someone to file a motion. Hopefully, Judge Glenn will watch this. Maybe you knew all this all along, but I just wanted to move everything forward just in case, so that we can really move forward and get those property rights assigned, because that is going to put off many of the bidders, and the bidding process is essential. And also the examiners and all the regulators are going to object until we've got these property determinations. Now, 10th of December is when this main custody piece is meant to be resolved. In the last hearing, you said, let's add stables to that. And I think you're going to have to find another 8 things, or 8 in total, to add to that. And I think they should be treated and resolved by the 10th of December, so that this doesn't get in the way of what needs to happen in order for us to get the types of recoveries through the bidding process that we need, so that we don't get unnecessary delays and the worst outcome that we really don't want. From speaking to most creditors, and I can't speak for all creditors. I'm speaking for myself as the 21st largest and just somebody that has heard and spoken to a lot of them. Okay, so that is my message for Judge Glenn, and for the community to go out there, file motions, and maybe there's a few more that you want to add to this and add more detail, but I'm focused on the bidding process. I don't have time to do these things, but I hope this really is useful in progressing. The rest of my message is simply for creditors. So I'm just going to be speaking to creditors on some of the things that we've been working in order to progress as well through the next parts. So the second thing is that I think personally, I have come to the conclusion, and many people, that with these talks of Ponzi schemes and determinations and examinations and all that type of stuff, we need to get through a compliant bidding process, and hopefully we can stick to the targets. I do believe there will be delays. It's due to get through, be complete by Christmas. There's a lot to do. There's a lot of time pressure. I can't talk about, anything that's non-public information, but the compliant bidding process requires several things in order to get through it. And I see so much misunderstanding. So firstly, from my perspective, if you haven't watched the video series that I released as a creditor, please watch those videos. There's 7 videos. They're about 30 to 35 minutes each. I know that's a lot of content, but I believe that if you are a creditor, it's vitally important that you've watched this. I presented some ideas of how the creditors can get whatever coins they have left back, equity in the upside of all the assets that were bought with our money, and giving everyone a home for their loans. And unless we can achieve all 3, I believe we get a suboptimal outcome. and we get this fragmented piece. Because, for example, if you bid off the loans without bidding off the collateral with it, then you have this big problem. You'll get motions filed, you'll get delays. If you bid off GK8, the custody service, without having a compliance layer on top of it, then that could harm the equity value. If you take the mining bid in isolation, you can hide, you can hurt what could be the end result for the equity. And so no matter how many times I've gone around this, unless we can put those and bundle those together as a compliant home for coins, a compliant home for the equity, and securities that give the potential to fill the hole, and a compliant home for the loans, and then a negotiation, whatever happens in court. So that's what I wanted to help you understand, that if we can just get the determination in court, we can put together market solutions to resolve it if you don't like where you are. So that's why the compliant bidding process, we've been focusing on regulated solutions. Regulators need to sign off on the solutions as part of that process. And then there needs to be an assessment about whether there is enough funding to execute the vision. And then there is an assessment about whether all the clients are going to run away, and how you actually get those clients to stay. So obviously, from my perspective, the lowest level of trust is Celsius, because that's where the trust issue is. And so that would typically have the lowest retention of clients. Even the Celsius management said that in the leaks. And then you've got higher levels of trust, which comes from capital, regulated solutions, management, and various other things, and just good products that people want. And so in order to do that, there are 3 different layers to the regulated solutions that need to come through in the bidding process. You need regulated custody, so the ability to stake, the ability to give people their funds back, and then be held in custody. That's a regulated solution and a technical solution. That has to exist within the US and outside of the US. The same with the Earn program, or issuing equity to people. That would need to be done through a regulated securities business in the US, a US broker-dealer, or a regulated securities business for those clients outside the US. And so in order to issue that equity and have a market where those that want to sell or those that want to buy after lock-in periods and various other things, they need to go via regulated securities businesses. And if you want to even lend to that business through an Earn program, then that is a security at the moment. So in order for the Earn program and to issue equity, you need a securities business. To receive the coins back, you need a custody and the regulations there, both US, non-US, US, non-US. And then finally, loans. So I've just obviously put Bank to the Future here. We have a solution with a custody bank for that, and various other solutions that we have outside US and inside US. This would all be assessed by regulators, so they're going to have to go through that process and reach a determination to get through a compliant bid. This is why it's important that we get property rights assigned and we understand and we're not wasting time. And then you've got the security side, which is what we as a business have been doing at Bank to the Future for all the years. So all those case studies of companies we've worked with, that was issuing securities. And if we were to engage in someone investing in our company or lending us some money in an Earn program, that would be done as a security through those appropriate measures. And obviously Salt, the first crypto lending platform, worked a long time on securing those lending licenses, doesn't have complete coverage. So there would be also a roadmap of all these additional licenses that would need to be achieved in order to offer those services. So I just wanted to help you understand. And if you watched them already, make sure you go back to the 7-part video series where I touched upon what I think a compliant solution that achieves the goals of giving these assets to creditors so that they can get the best result possible without having to sell those assets to somebody else's shareholders, which is what the bidding process will do if we don't get it in the right way. So that's that 7-part video series. Please do go back to that and review that to understand what I think the key points are here. You can object to those. You can have different ways of doing it, but it lays out a framework. And really, it just comes down to the simplest thing. which is we need a regulated home for these different three pieces. We need a bidding process, and we need to ensure that the assets go to creditors. You get your coins back in custody. If you are investing, then it's done as a security. And if you've got a loan, there is collateral and a home for those loans that meets the obligations of these different businesses to do that. Okay. So I also wanted to share that we have been working on our Chapter 11 solutions. We'll be presenting, I'll share some screenshots of the work that's being coded at the moment. But as I said, we're going to be working on an offering at Bank to the Future, like we did with previous plans, where people can actually invest in BF Global to be a part of this bidding process. So if you don't have your account at banktothefuture.com, please get that in advance. We've got thousands of accounts coming through right now. There is a waiting list, so ensure you do that in advance to meet the goals and the higher bar of security law compliance. We need to go through a certification process and a bit more than what you're used to now that we're doing this in a way through securities laws. But also, we're going to be doing a debt offering, not just an equity offering. So that means that essentially those that want to return to the earn program, but done through a security, then they could lend some coins to BF Global without creating those events. And therefore, that is essentially a way of us being able to ensure that we get a creditor-led bid through this process. So we'll be sharing more details on that. So finally, I wanted to go through some of the different products that we're building right now for what I call creditor rebalancing. So the reason that I think is very important for the court to make those determinations ASAP of who owns what is because, firstly, you should be fighting for what you want, or you should be accepting that there are negotiations in those different parties when you consider them. They have to be determined all at once for all the reasons that I've given, rather than one at a time and just going on for months and months and months. But if you don't get what you want, we can do what I call creditor rebalancing. And creditor rebalancing is essentially just appreciate that we're saying that at the moment we're acting out of scarcity, where we're all saying, I want my coins, there's not enough coins. But if people can be compensated through equity, then there is also a security. And so really it's just a question of, do you want more coins or do you want more securities? So we're building products in order to rebalance that at the moment. And I'll just share a few screenshots before we go over to the Twitter space. I'm about 3 minutes over right now. But this is a new feature that we're very excited about bringing to the market. And if you have an account on Bank to the Future, you'll be able to beta test this, where essentially you can just connect your Celsius account. You can import it based upon the data, connect your account based upon the data to your Bank to the Future account, and it will pull through all of your balances. You can also, to verify it, to double verify it, take a screenshot of your Celsius account, upload it to your Bank to the Future account. This feature's not live yet, but we'll update you as it goes. And we'll be looking for beta testers as well. And it can pull through your claims for Celsius on your Bank to the Future account. Now, we'll be making a portion of that whereby it could be available for you to engage in some kind of rebalancing process. Maybe you want to invest in some equity. Maybe you want to lend it in an earn program, depending on the outcome of whether a successful bid occurs. So this is where you can control the process of engaging in this, using financial innovation, just like we did with previous deals, ahead of this process. So, many people are feeling useless, that they have no voice at the moment. This allows us to do it through securities, and will be also, this is the Bank to the Future identity solution will just only allow those that qualify, those that don't qualify. We've got the different brokers that are coming through. But it doesn't mean, you can't receive equity in the future as part of a settlement. So just tell us who you are, and then we can ensure that you get access to the right things available to you. Then, for example, you could take some of those claims and you could say, well, I want BF Global to engage in the bidding process. I'd like some equity if I qualify for that. or I'd like to actually lend some of my coins to ensure that there's enough there in order to win the bid. Because at the end of the day, here's the hard talk that I've been trying to share with people on Twitter, is that now we are hitting crunch time. And money talks as this process. So firstly, we need to get it signed off with the regulatory solutions. Then there needs to be enough capital to make it feasible. And then there needs to be solutions. And this is why I'm so keen on securities as well, because there you get 100% retention. Everybody will stay on Bank to the Future in order to gain access to their securities. They can't leave the platform, but then we can give you your coins in custody and you can decide, put them in a hardware wallet, stake them through the custody service, use them as collateral for a loan, and just do whatever you want based upon your trust without creating the same problem of a bank run. Once you've got those securities, we have markets, there's lock-in periods based upon the different securities laws, but then we could say, just rebalance yourself. So you might say, well, I didn't get all of my coins back, but I did get some equity. Therefore, I want to place my equity to somebody that wants that so I can get my coins back, and then I can hold them in custody and I could convert them to Bitcoin, ETH, I could stake them, I could do what they want. So it may not be the exact solution and your ideal solution, but I just want you to appreciate that when we put these solutions together, everything can be rebalanced. So I just wanted to share with you that these are some of the creditor solutions that we're building. Please do get ahead of it on the waiting list right now. And we can share with you some of these beta products. We'll be betaing it on the Celsius Chapter 11. And you just need to create your account at banktothefuture.com, verify and certify yourself. Okay, so that's all I've got. Just in summary, I'm not expecting Judge Glenn to have stayed till the end, but in case he did, the message is we want to ensure that these different issues don't go on for months and months and months, and they are resolved. Even if they're not, the bidding process needs to continue, because if we end up in a Ponzi determination, we need everything to know that there are much better outcomes for creditors than doing the wrong thing for creditors. And that's the important part of this process. We don't want to be fighting over property for months and months into 2023, and then we don't want a bidding process that never happened. And then the examiner reports come through, because we need to show that we believe that regulators can pick the best outcome for creditors, rather than going to where the examination report may take this. Because I just want you to appreciate that treating this as a Ponzi or various other things, like was being discussed in the court, would lead to absolute financial disaster for so many people, when we believe that it's not necessary and there are assets that can be repackaged, and compliant solutions can be built, and we can create a new industry standard together here, and we can really use market solutions to satisfy those that didn't get the court determination. So now I'm going to move over to Twitter Spaces. I think my Twitter account, let me just do the final. Okay, I had the whole, that is not legal advice, not tax advice, not investment advice. You need to seek your own there. And I'm going to go over to Twitter right now at Simon Dixon Twit, and just do one quick AMA. The reason I'm doing this as well, just a final piece, before I move over, is actually my birthday tomorrow, and I'm taking the day off from Celsius to do the things that humans are meant to do when they're not working on these crazy processes as well. So I won't be doing my usual AMA, so I'm going to do that right now, and I'll see you over on Twitter. Remember, we're doing this with peace, we're doing this with love, we're doing this with unity, and I'll see you. And I'll always remember, you are alive at one of the most interesting and exciting times in financial history. Disaster for many. More and more people in the traditional economy and crypto economy. I want to make sure that we're on the right side of the chain.